really good. So, I mean, I believe that the method that we would like to implement, let's say, has been understood and works. So, let's see now, of course, being this the first case discussion, if needed, I will support you. Second information, for those of you who do not have the book yet, please consider that this morning several copies have been delivered to 110 Lode, the bookshop close to Via Parenzo. So I suggest you to go there because the online copies on Amazon and the CEDAM website appears to have been finished. So you should go there.
The 3 of us, the app is not working and it says...
Yeah, you should send an email. If you have this application that doesn't work, and I believe it's like 50% of the students, send an email, okay? And we will take notes. Send an email to me. So, books, okay? Third, I believe there has been a little bit of misunderstanding about the cases to be discussed because today you are discussing KR Energy, which has been discussed also by the other group. Actually, in our idea of the case discussions, we should, let's say, discuss 2 cases a week. So group 1 discusses a case, group 2 discusses another case. So, no issue, of course, for this week. Starting from Tuesday, in 2 weeks, we will have 2 different cases, one for group 1 and the other for group 2, okay? Last thing, today you are discussing in 5. For me, is not an issue. I would prefer to see, let's say, smaller groups of people. Then let's see how you manage your time today discussing. No problem for you, but I would like to see groups of 3-4 persons, okay? Also because I believe that this discussion takes more or less 40 minutes, so it's easier for you to manage your time if you are a lower number, okay? So, floor is yours. I will intervene whenever needed in order to clarify and provide inputs, okay? Thank you.
Good morning, everyone. I'm Ludovica. Today, with my group, we have the pleasure to present the KR Energy case. This one is a content needed. First of all, we explore the case of class, but also a legal and theory framework to better understand the case. The case concerns KR Energy SPA, that is an Italian listed company operating in the renewable sector, which carry out a share capital increase through contribution in kind of the entire share capital of our company, that is SISPA. The shares were evaluated by an independent expert under the simplified procedure, where in the extraordinary shareholder meeting, all the shareholders, including that one of SISPA, voted in favor. But for now, it's better to have a legal framework and to better understand the main concepts that are the capital increase and the contribution in kind. As we know, the capital increase can be made through cash, receivables, and contribution in kind. That this last one are regulated by the Italian Civil Code in the article 2343, 2243 and quarter, and 2440. Which the main objective is to protect their interests and of the shareholders and creditors, ensuring correct valuation of the asset contributed. There are 2 main procedures. The first one is the ordinary, where the expert is appointed by the court and the shares remain unalienable until the final verification. And the simplified one, that is the procedure that happens in this particular case, where the expert is evaluated, is nominated by the parts, but then we explore this procedure in more detail. Continuing on a legal framework, there are some directives at European level and Italian implementation. First of all, there is the company directive, which the main objective, as I said before, is to protect the shareholder and creditors, ensuring that the capital must be real, paid, and maintained, and to avoid illegal distribution or poor reductions. Then this directive was amended by another directive, that is the 2006-68 EC, which introduces simplified contribution, where the cost expert, as we can see later, is not required always, and also introduced that the nominal value of the contributed asset should be at least equal than the share value plus the premium. According to the Italian implementation, regulated in the civil code, it introduced another rule, that is, if the value of the asset contributed is less than 20% than declared, the shareholder must reduce the capital or cover the capital, but also they may withdraw from the company.
So, thank you, everything is correct. I would like to focus for a moment on this legal framework. So, just in order not to leave anything behind, I believe this is clear to all of you, but just to refresh it. So, the circumstance that the discipline we are talking about today stems from a European directive means that this discipline is harmonized at the European level. Because how does it work with directives and regulations? I believe these are concepts you are familiar with, but I would like to refresh them a little bit. So, the directive is the piece of law coming from the competent legislative authority at the European level, which sets forth an objective and gives the member state the discretionality in order to identify the ways to achieve that objective. Okay? This discretionality can be wider or stricter, and thus giving, let's say, more room for amendments at a domestic level. The stricter is the discretionality that is left to the member states, the more similar will be the disciplines in the different jurisdictions, okay, at the European level. So, in other words, the directive fixes the objective and the member states have the power to implement domestic provisions aimed at achieving that objective. So, the directive must be implemented, as your colleagues mentioned in the slide, in the domestic jurisdiction in order to become effective. Regulations are the other piece of law that is, let's say, used at the European level, and they differ completely from the directives because the regulation is immediately effective in the recipient member state. So the provisions of law that apply in Italy, in Spain, in France, etc., are those contained in the European regulation, word by word. In the directive, instead, these provisions may vary between jurisdictions, again, because the European legislator only identifies the objective, in this case, the protection of the creditors and the shareholders, and the effectiveness of the share capital, and then leaves to each country the faculty to identify the most suitable remedies that they deem to implement. Okay, any questions on this? So this is a very short recital that I wanted to make because you have to understand that what we are talking about is, let's say, common principle in European jurisdictions. Of course, there may be slight differences between jurisdictions. Please.
Continuing with the legal framework, I present the simplified procedure that is ruled by the articles 2343 ter and 2343 quater of the Italian Civil Code. As an alternative to the traditional process, the simplified procedure applies only in case of contribution of transferable securities or money market instruments under letter A, under letter B, the assets kind or receivables at the fair value recognized in the last annual financial statements of the contributing entity, and under letter C, assets in kind or receivables at the value resulting from an unsworn evaluation drafted by an independent expert appointed by the court, by the contributing entity, but no later than 6 months prior to the contribution. In all the simplified cases above mentioned, the corporate procedure doesn't require the appointment of an expert by the court. In the case under the letter A, that is the case of the contribution of transferable securities or money market instruments, it is required if the value assigned to the contributed assets for the share capital plus the premium is equal to or lower than the weighted average price at which the contributed assets were traded on one or more regulated markets in the 6 months prior to the contributions. If the contribution instead concerns other assets in kind or receivables, and then the ones under the letter A, the paragraph 2 of the Article 2343 ter provides 2 cases in which, under certain conditions, the appointment of an expert by the court is not needed. In the first case, if the value assigned to the contributed assets shall be equal to or lower than the fair value recorded in the last annual financial statements of the contributing entity, provided that the financial statements are audited without any negative comments by the auditor. And in the second case, under the letter B of the paragraph 2 of the Article 2343 ter, is sufficient a report drafted by an independent expert with adequate and proven professionality, even if appointed by the contributing entity. In the context of the simplified share capital increase, the management body of the company takes higher responsibility for the valuation of the assets provided by the potential investor in comparison with the traditional procedures. In fact, the directors firstly have to file a statement with the company's register within 30 days from the date on which the contribution has been made. Moreover, the directors are required to certify the non-occurrence of exceptional events able to significantly change the value of the contributed assets, as well as whether or not the requirements of the professionality and the independence of the expert are met. In addition to that, until the statement of the board of directors is filed, the newly issued shares are not transferable in alienable and must remain deposited at the company's registered office. On the other hand, the shareholders, pursuant to the Article 2440 of the Italian Civil Code, if they represent at the shareholders meeting resolution at least 1/20 of the share capital, that is equal to the 12% of the share capital, have the right to ask the directors a new valuation of the assets to be contributed, thus following an ordinary procedure of the estimation of the value of the assets.
So, if I may, before moving forward to the facts of the case, can we go back to one of the first slides where there were like cash, receivables, so, this is what we're talking about today, and the next slides, which are very useful, go more in detail into the procedure that the Italian Civil Code, according to the indications coming from the directive, provide for the evaluation of the contributions in kind. So, in terms of main principles, can we go back to the other one, this one? I believe that last Friday you have been talking about with Professor Manni of share capital, right? If I'm not wrong, I think. So, today we are discussing how the legislator makes sure then that when a portion of the share capital of a corporation is subscribed by means of a contribution in kind, how to make sure that that contribution in kind is properly evaluated. Why is this important? The share capital, as you know, is, let's say, the nexus of annexes that the company must have since the very beginning of its life and must remain unaffected for all the life of the corporation because they are the main guarantee for the creditors. Okay? This is the share capital, and based on the amount of share capital that each shareholder owns, you calculate the amount of rights that that shareholder can exercise. So 50% of the vote, 50% of the dividends, etc. The share capital can be amended, of course. It can be reduced, it can be increased. In this case, KR Energy case, we are talking about an increase of the share capital of an Italian listed company. Why do you want to increase the share capital of a corporation? Because you need to collect additional financial resources on the market from third parties in order to finance the business of the corporation, to develop a business plan, to make new acquisitions, to launch new products, to open new business units, to hire new employees, etc. You need money from the market. This is one of the ways in which an investor, a third party, can become a shareholder of a company. The second way, of course, is by buying the shares from an already existing shareholder, which is the main difference. Let's suppose that they five altogether, they are the shareholders of a corporation, and I want to become a shareholder of that corporation. I have two options. Either I buy some shares from one of them, all of them, a portion of them. So they are selling me shares, I am paying to them money. This money goes in your pocket, not into the company. So I am not financing the company, I am paying to you a price. The company doesn't get nothing, okay? First possibility. Second possibility, the company in which they are a shareholder resolves approve a share capital increase. So, practically speaking, the company opens up its own share capital to a third-party investor, me, who injects money into the company, and in exchange I receive shares of the company, new shares. Okay? Now, have you been, please?
However, with the share capital increase, that's the dilution problem.
Exactly. Can you talk about that?
Yes, of course, because when
I don't want to anticipate anything you will be talking later,
No.
but I expect this to be covered, so let's speak about that.
Okay. When an investor has a portion of the stake of the total amount of the shares of a company as is on stake. When happens a share capital increase, when the company resolves it, then the total amount of shares increases. So there's a proportional dilution of the stake, of the percentage of the stake of this investor. But this can be resolved with the option right that the investors, that the shareholders of a company have. But in some cases, the option right is excluded or limited because of the decisions of the company.
Exactly.
Yes, also this type of procedure with capital with contribution in kind is not granted to the option right for the existing shareholders.
This is very true. So, in very unsophisticated words, compared to what you said, if I have to become a shareholder of this company, they have to make room for my entry into the share capital because I will become the sixth shareholder. So their stakes, which were 20% each, let's suppose, they will be diluted. Do your own math, I don't know to which percentage, in order to make room to me. Okay? This is the dilutive effect. The remedy that the legislator provides in order to avoid the dilution is the option right, as your colleague mentioned. The option right allows the existing shareholder to proportionally subscribe the newly issued shares so that even if the share capital increases, their stakes remain the same. Okay? As your colleague mentioned, in the case of a contribution in kind, the option right is excluded, and therefore a dilution is always present. Why? Because the legislator believes that the rationale behind a contribution in kind is the fact that the company explicitly targeted that asset in order to be, let's say, incorporated in the share capital of the corporation. I don't know, a prestigious building. You have this amazing company, you want to change the registered office, you want a building in, I don't know, Via del Corso. I own a building in Via del Corso. They ask me, do you want to invest in our corporation? Instead of putting money, contribute your building. And in exchange of your contribution, we will be diluted and you will get new shares. Okay, this is the mechanism. What this entire regulation that we are talking about today aims at ensuring that what I contribute in kind is actually worth the value of the share capital increase and therefore your dilution. Because what can happen in lack of a discipline like this? Let's suppose that they resolve a share capital increase of 1 million euro. I come at your company and I say, I want to invest, I want to subscribe to this entire share capital increase. Here is the asset, this phone is worth 1 million. Okay, we all know this is worth, I don't know, 300 euros. What is the problem? Is a double problem for them and for the company. Why? First, when in the future the company will be liquidated, will have to pay debts, will have to pay advisors, etc., the company, and particularly its directors, rely on the fact that in its own assets, there is one asset that is worth 1 million. When you go on the market in order to liquidate the asset and obtain the cash to pay, you discover that it's worth 300 euros. You have a huge problem, because that means that your assets are actually not worth as much as you thought. Okay? First issue. Second issue is for the shareholders, because you have accepted to be diluted and therefore to reduce significantly your stake and allow a new investor to join you based on a contribution in kind that is worth nothing. So not only you have been, let's say, diluted for nothing, but I have become shareholder of a company where you put real money. So I am taking a portion of your money through a contribution that is worth nothing. This is the reason why we have this strict regulation that aims at ensuring that when a contribution in kind is made, that contribution is properly evaluated. Okay? And we have two methods in order to do so. An ordinary one, that is, let's say, the method that, as your colleague mentioned, can we go to the slide of the responsibility? Says, let's say, entails a lower responsibility for the directors. Why? Because in the ordinary procedure, you are involving an expert that is appointed by the court. Okay, so this is a pro for the company. The cons for the company is the fact that, especially in Italy, if you ask the court to appoint an expert, you have to wait 3 months. And maybe you need to do the share capital increase as fast as possible because you have a business opportunity that you want to catch immediately. You need money, and so you decide to avail yourself of the simplified procedure. The simplified procedure indeed is the, let's say, most common procedure. The difference, huge difference, as you mentioned, is the fact that the expert is appointed by the parties, meaning by the board of directors, and therefore the board of directors undertake the responsibility of the decision, one, to avail of the simplified procedure, two, of the choosing of the expert. This case is all about that, so I just wanted to set, please.
Moreover, in the simplified procedure, so as the professor said, there is higher responsibility of the directors, and moreover, there is an higher possibility of contrasting from the other shareholder about the possibility of fair value estimated of the share.
Yeah, which is what happened in the KR case. Because, again, since the expert is appointed privately, not by the court, there are more chances that the shareholders decide to challenge the evaluation. Again, why the shareholders should be interested in challenging the evaluation? Because if the expert attributes to the asset that is being contributed a too much higher value, they see their stakes reduced for nothing. So they have an interest in doing so. Okay, please continue.
So, building on what my colleagues have just said about the legal framework, now let's talk about the facts of KR Energy case. So KR Energy SPA is a publicly listed company, and such it is subject obviously to much more stricter regulations and enhanced disclosure obligation, and obviously it is supervised by the concepts of the Italian securities regulator. And so every transaction that affects the increased share capital needs to be handled with particular caution and care in order to, especially the one in contribution in kind, obviously to balance and to safeguard the market and all the shareholders and the creditors. We know that KR Energy wanted to increase its share capital through the entire contribution of the share capital of SISPA, and this procedure was brought up by following the simplified procedure, as we said, under the Article 2343 ter, paragraph 2, letter B of the Italian Civil Code. And unlike the ordinary procedure where the court, there is a court-appointed expert that actually proposes the valuation, and so the shares become inalienable until the record of the court is deposited. Through the simplified procedure, the parties agree on common agreement, decides on an independent expert that proposes the valuation. Obviously, it's much more quick, it's much more cost efficient, and so it is the rationale behind it. And through the KR Energy case, we know that the independent expert approved the fair value of the share capital, and the civil code says, and also the corporate rules, an extraordinary shareholder meetings was convened, and during these extraordinary shareholder meetings, all the shareholders were called upon to approve this increase in capital, and also have to see that everything was under law. And after it was approved, they have to give the rights, obviously, also to the minority of shareholders to exercise their voting rights. And so this is a stage where the company has obliged to all the laws and all the applications, it follows all the transparency process and the governance standards. But this stage is going to be changed by what my colleague will say, because some shareholders brought up some challenges and some issues that are going to like develop in this case. So my colleague will talk about this.
Hi everyone, I'm Samuele, and now we're going to go deep into the case and understand why and what happened. So what are the problems here? We can see that, as written here, SISPA requested a new independent expert appointed by the court to review the previously appraisal. So they basically asked the court to involve the court involved into the case, and so they asked to go through the ordinary process and not go into the simplified procedure. They are in this request, even if they already voted in favor of at the oral meeting, they already voted in favor of the evaluation. At the same time, KR Energy Board rejected this proposal, and the rationality behind this is the fact that they already have voted in favor of this evaluation, so they do not have anymore the right to express this request. Then the case is not finished, and shareholders appeal to the court. So basically, they ask the court two things. The first one is to suspend the execution of the board resolution, and the second one is to dispose the inalienability of the new KRG shares until the final judgment. So they ask to wait until the final judgment and leave the shares inalienable. The Court of Milan decision then go.
Yeah, before we move forward, I just want to, can I use the dashboard for a second? Just want to be sure that it is clear to everyone what are the implications of the contribution in kind that we have been talking about those, because I don't think this is CSPA that challenges the resolution. I believe it's someone else. And namely, so we're talking about a situation like this. Okay, this is KR Energy. KR Energy listed company is resolving to increase its share capital, right? So issue new shares. This share capital is executed through a contribution in kind of shares of this company that is CSPA, right? So there will be the shareholders of CSPA that contribute in kind into KR Energy, and therefore they become shareholders of KR Energy. The shares this is CSPA. Okay. They contribute in kind these shares, and KR Energy becomes the 100% shareholder of CSPA. Okay, so they are basically moving the shares here and are becoming shareholders of KR Energy. Is it clear to everyone? No? This is what happens. So, who can have a problem in how this company has been evaluated, in your opinion?
Both SISPA and both the shareholders of KR.
So, both SISPA and the shareholders of KR are correct.
It depends on the evaluation, of course. If the evaluation
Exactly. The SISPA for its greater shareholder and KR shareholder for the
Exactly. So, these are the shareholders of KRA, okay? They may have an issue here if the stake in this company, CSPA, is evaluated too much compared to its real market value. Because they will be diluted too much, right? Similarly, they, the shareholders of CSPA, which contribute to the stake in KR Energy and become shareholder of KR Energy, equally they have a issue if vice versa, the value of CSPA is too low, because they will get a too short stake compared to the value. So Who can challenge the process here are these two, not the company. It's not a SISPA claim.
Is the older shareholder
Yeah,
just
exactly.
explain that better?
Yeah, but just to clarify that for the benefit of everyone, who are the interested parties here that can challenge something, and the
Particularly because the main company is the serial one, so the like one, they are now like one big company.
exactly. So we are talking about a claim that comes after this one, the extraordinary shareholders meeting of what company? Of KR Energy that approved all this transaction. After the approval of the transaction by them, one of them and maybe some of them challenge this entire transaction after the approval. This is quintessential. Please continue.
Exactly. So let's now see what is the court decision. And basically the court stated two things. So the first one is the fact that the court recognized the right of the shareholders to request the ordinary procedure, and so to request a new evaluation. But this right is valid just before the registration, so before the closing of the book, and so before the registration in the competent register of companies of the register of the companies. And from that moment, no further ordinary appraisal can be requested. The court also stated that this is not a problem in terms of right of the shareholders, because the shareholders are all anyways protected, since they can seek damage and seek for compensation damage by appealing to another court and by starting a new process. The second statement of the court is the fact that they rejected the request to dispose of the inalienability of the newly issued shares. And the duration is the same. Since the request, or those two requests comes after the closing of the book, after the registration of the book in the company's register, they do no longer have the right to request the ordinary procedure to come up and the inalienability of the newly issued shares. Okay, now Federica will come up with some discussions and regarding that we will.
Hi, my name is Federica. I'm going to handle this business case by showing you going deeper in the Milan Court. As my colleague said, the Milan Court had rejected the shareholder request in order because of the registration of the contract in the company register. Basically, what the Milan Court is saying that it is irrelevant if the 30-day period has elapsed or not, due to the registration in the register of the company, because it is already occurred. So the Milan Court agreed with the shareholder idea that could have been possible that in the interim period there were municipal subsidies that could have undermined the reliability of the valuation. But the court agreed about the fact that in a simplified procedure, the share capital must reflect the actual value of the contribution to ensure a fairness transaction. So, in order to protect these creditors and shareholder interest, the director are still required to ensure that no exceptional circumstances exist. This is what this means that, in our view, in respect to these main principles of protecting the shareholders and creditor interest, is crucial, or our best practice could be, to carry out an additional appraisal, not to invalidate the transaction, but only to verify the fairness of the process, just to provide the compensation of foreign damage that my colleague Samuel talked about. So we figured out to adopt. We talk about these main issues, so protecting shareholder and protecting creditors. So there are two main articles in this case, which are the 2440 of the 6th paragraph of the Italian civil code, and the 2343 paragraph 3 of the same code, which basically, in one hand, we have the right of shareholder to request another evaluation within the 30-day period. But at the same time, on the other hand, we have the fact that the registration of the statement in the company register has an immediate effect due to the fact that, as the professor said, it is application of the European directive in the Italian code. So we basically thought about that. We figured out that how these can two principles coexist without undermining the shareholder right to be protected. And our best practice would have been to delay the possibility of the registration in the company register until the 30-day period, just because to ensure the fairness of the process and ensure the right of shareholder to request an additional evaluation.
This is a good suggestion. It is actually a best practice that is implemented. Just want to focus for a moment on this registration in the company's register now, because it has been mentioned many times. I want to be sure that we are all on the same page. So, in Italy, but also abroad, commercial companies such as joint stock companies, limited liability companies, etc., they are subject to a mandatory disclosure regime vis-à-vis third parties, meaning that certain documents concerning the company, such as, for instance, the financial statements, such as, for instance, the minutes of the extraordinary shareholders meeting, such as, for instance, the articles of association, the bylaws of the company, they are filed at the business register, which is a, let's say, platform that is freely accessible by the public. Okay? A third party, by entering into the business register and introducing the information about a corporation, such as tax code, name, registered office, etc., can download by paying a symbolic amount of money all the documents that are public by operation of law, so they are mandatory public and filed at the business register. Now, the rationale behind this disclosure regime that is provided under Italian law and again in other jurisdictions is to allow third parties that have to deal with a corporation, enter into a contract, decide whether or not to make an investment in equity, in debt, etc., etc. The rationale is to allow these third parties to understand what kind of corporation is that. So the consistency of the share capital, for instance, because the number of the share capital is indicated in the bylaws of the corporation, to check the financial statements, to understand what is its corporate governance structure, etc. Now, please consider that the statement that your colleagues are mentioning is a statement that is issued by the board of directors at the end of the corporate procedure of a share capital increase, and by means of that statement, the board of directors certifies that the share capital increase has been positively concluded. Okay? This statement is filed at the business register. All the third party become aware of the fact that that company has completed a share capital increase. New shares have been issued in execution of that share capital increase. An investor has subscribed those new shares and has become a shareholder of the company. This is what a third party understands from this statement. Okay? Now, why, until this statement is filed at the business register, the shares, the newly issued shares, are inalienable, sorry. because until the statement is filed, you cannot know if you will complete the share capital increase procedure, and so you want to avoid that those newly issued shares are sold, circulate among the public, because what happens if then I do not complete the share capital increase, or there is a problem with the valuation and we have to do everything again? A third party that in the meantime has bought those shares, excuse me? No, would find himself to have bought a piece of paper, something that is not worth, because exactly, those shares have been issued, but the share capital increase has not been completed. So me, a third party, in the meantime, I have bought those shares, but they worth nothing. Okay, it's paper. In order to avoid that a circumstance like this happens, the Italian legislator provides that in the moment between the approval of the share capital increase and the filing of that famous statement, the shares cannot be transferred, they are inanimate, okay, to avoid this. Vice versa, once this statement is filed, the best interest to be protected is the one of the third parties. Because if you invalidate the share capital increase by claiming that the value was miscalculated, after the filing of this statement, the individuals that risk to be damaged by such an invalidation are the third party that in the meantime have relied on the fact that KR Energy has positively and validly completed the share capital increase. They may have bought shares. They may have, for instance, if I am a bank, granted a financing to KR Energy because I know that KR Energy has now the money to return the financing. Okay? If KR Energy is a, let's say, public contractor, maybe he wins in the meantime a public tender to create an infrastructure because as KR Energy the financial requirements thanks to this share capital increase. So many things can happen after the moment in which you file this statement, and go back and invalidate everything for the interest of few shareholders is, in the perspective of the legislator, a lower interest, an interest with a lower ranking compared to that of the all different third parties. Okay? This is the rationale behind the position taken by the court. And for the purposes of this case, what is really important is the step plan, the timing of the events, of the challenge, after the approval, after the filing, blah, blah, blah. Okay? Clear to everyone? No? Thank you, sorry for the interruption.
We just finished.
Okay.
It was our critical point of view. So there is the Q&A session.
Very good.
If there is.
Any questions? There is one, please.
More of a curiosity-based question. Given your critical standpoint on how these two different regulations overlap each other in a way, how do you see the following of your critical view, so your opinion, how do you see that and the effectiveness of that in comparison to the ordinary approach?
Basically, Professor Sir, the ordinary procedure compared to the simplified is more precise, we can say, because there is the independent expert appointed by the court. But if this doesn't mean that in the simplified procedure there are no obligations. So as my colleague said, Flavio, there are more obligations for the director, and there is still the obligation to ensure the fairness of the transaction with a fair value of the estimated share and assuring that no circumstances exist with that could undermine the procedure. So for sure the case probably will not exist, because if our expert was appointed by the board, there was not the possibility to an uncorrected and unfair value estimated. But the main problem in this case is not that, it's about this time lapse period, this 30-day period that's elapsed. Because they have appeal about that, saying, for example, we have this 30-day period to make our request. But at the same time, there is this article that said that after the registration, you cannot, you lose your right to ask that, as the professor said, in the interest of the third parties. So we talk about that just to balance these two interests, because it appears to me pretty simple to ensure both interests from the shareholder and creditors and the third party side. Just delaying this period to register the company is just 1 month. I don't think it's a big issue to wait until that. So simply because we are talking about a simplified process that from its definition is shorter in time from the ordinary one that would be like months or maybe years, I don't know. It depends on the procedure that and the company that we are looking for. But yes, this would be the best practice for that. Both, I think, for the ordinary that for the simplified procedure.
Yeah.
Then I would add only that in any case, the, let's say, interest of the minority shareholders is, even if in a different way, protected by the fact that they can claim compensation for damages.
Yeah.
That is something that you cannot move, because you know, in corporate law, you have two big clusters of remedies, no? On the one hand, you have remedies of a, let's say, a real nature. So, claims that you bring to the court in order to revert a resolution to the status quo ex ante. I mean, we approved a share capital increase, I challenge it, you have to do it again. Okay? Real remedies. On the other hand, you have compensation for damages claims. So when you are not able anymore, like in this case, to revert the factual scenario because the share capital increase is done, you cannot invalidate it anymore, you can always claim compensation for damages. It's a different achievement because no one can give you back your dilution in the company, but you will obtain a compensation in money, in cash. Okay, so this is something that we should always remember. Thank you. That was very good in my opinion. It is what I expect. I still believe that, let's say, composition of groups in a smaller number would be beneficial because, for instance, you had the chance to speak only for half a slide. And therefore, for instance, a group of 4 would have had a better allocation of time among discussants. In any case, slides are very good. I strongly invite you to share them with your colleagues so that you all have a support to study the applicable legal framework. And also, I really liked the critical view at the end, so congratulations. This is what I expect from this discussion. Thank you. Thank you very much. So, if you allow me, now we have 30 minutes. I will not use all of them because I want to give you some brief, but I would like to use 15 minutes of your time to, let's say, stress a couple of concepts concerning corporate governance. That's the mechanisms through which decisions are taken in one company. Because today we have been talking about shareholders meeting, board of directors, etc. So I want to be sure that you have clear in your mind what we're talking about. So you become familiar with the fact, with these, let's say, concept here. So, when we study corporate governance, and namely the rules that govern the functioning of a corporation, this is the meaning of the expression corporate governance, we have a number of so-called agency problems. The first one and most common of them is this one, principals versus agents, where principals stands for shareholders and agents stands for board of directors members. Why? As you know already, shareholders are those individuals or entities that have made an investment in equity into the share capital of a corporation. Therefore, they have become the owner, they have proprietary rights over a portion or the entire share capital of a corporation. Either they obtain those shares through a share capital increase and therefore through a contribution, or by selling and purchasing shares from an already existing shareholder, they have become owners of a portion of the share capital of the company, which is represented by shares. The circumstance that the shareholder is the owner of the portion of the share capital of the company means that he has certain rights towards the company, administrative rights, economic rights, we will see them, because he is the owner of a portion of the company. So, the shareholder, in his role of owner of the company and its own assets, needs to appoint someone to manage them. Here it comes the agents. Here it comes the board of directors. Meaning that the shareholders under Italian law, but this is shared among several jurisdictions, are not those who manage the company. The shareholders are the owners of the company because they have injected the financial resources into the company, but they grant a mandate to a third party, the directors, to manage the company on their behalf. This is why the board of directors members are agents, because they act on behalf of their principals, the shareholders. Okay? Of course, this does not mean that there is an incompatibility between the role of shareholder on the one hand and the role of director on the other hand. Think about, for instance, family business or let's say high intensity technology businesses where there is a founder of the company and therefore its main shareholder. He usually also acts as CEO of the company, so a member of the company with specific delegated powers, because he is the only one that has the capabilities and the skills to manage the company in the proper way. But also think vice versa to the most common situation of listed companies, for instance, where there are thousands and thousands and thousands of shareholders. These persons do not have normally the ability to run a corporation. They have made an investment for speculative purposes, and so they have an interest in appointing someone, a highly skilled professional with expertise in the industry, professional background, etc., in order to manage for them their investment. And this is why you form the board of directors. Okay? Now, the power of the shareholders to appoint the directors is the first of two main prerogatives of the shareholders in the so-called ordinary shareholders meeting. Ordinary shareholders meeting means that the shareholders gather together and take certain decision with a quorum that is 50% plus 1 of the votes available in the meeting. Okay? So, if this class is, let's say, composed, it represents the entire ownership structure of a joint stock company in Italy. And let's suppose that your colleague here, what's your name? Vivian. Has the 60% of the share capital of the company alone on an individual basis, and the rest of you have the 40%, she can take alone all decisions in the shareholders meeting, because she is the majority shareholder, meaning that if in this company that we have all together, we have to appoint a board of directors of, for instance, 3 members, these 3 members will be all appointed by her, by Vivian. Clear? This makes you minority shareholders, because you have the remaining 40%. And corporate law provides to you a lot of instruments to defend yourself for the potential conducts of Vivienne acting as a majority shareholder in her own interest, possibly damaging you. Okay? We will see them one by one, because that is the most important aspect of corporate law, because the fact that she has the 60%, you have the remaining 40, means that she controls the company. She can take this decision in the ordinary shareholders meeting, including the, let's say, appointment of the directors, and therefore, in a certain way, it's like if she is able to dispose also of the financial resources that we injected for your remaining 40%. Okay? And this is why you need to be protected. I said that this is the first of at least 2 major competencies of the ordinary shareholders meeting. Appointment of the directors. The second one is the approval of the financial statements. The financial statements, as you all know, because I believe you are very familiar with this kind of documents, is the document that gives a representation of the health status, I would say, of the company, and it represents, let's say, an annual appointment for the shareholders, no? Because according to corporate law, the financial statements must be approved every year within 120 days from the end of the fiscal year to which they refer. So, if we have financial statements as of 31 December 2025, okay, closing of the year, these will be approved within April 2026, so 120 days later after the end of the fiscal year. Based on the results that are recorded in the financial statements, the shareholders can take certain decisions, as you know. If there is a profit, for instance, the shareholders have the possibility to decide whether to distribute those profits among them, that is called a distribution of dividends, or they can decide to carry forward to the next year those profits and allow the company to finance itself. Now, these, let's say, alternatives, it is true that they fall within the competence of the shareholders, but the proposal to approve one or the other is prompted by the board of directors, of course. It is the board of directors that proposes, that submits to the shareholders the proposal whether to distribute a dividend or to finance the company. Why? Because it is the board of directors, the only corporate body entitled to manage the company, and it is the board of directors, the only corporate body that really knows what the company needs. I want this to be very clear to all of you. The shareholders, despite the fact that they are the principals of the company, they own the company, they do not have a deep knowledge of what happens into the company. What is discussed at a strategic, commercial and business level among the directors of the corporation remains within the board of directors. There is no right of the shareholders to become aware of what the board of directors has discussed. Indeed, we will study an entire discipline on insider trading. You have a problem if there is a leakage at the level of the board of directors, if someone breaches the confidentiality that applies to board discussions. And so there is a very strong distance between the board of directors on the one hand and the shareholders on the other hand. And this is why a document such as the financial statements is so important, because it helps to shorten this knowledge distance between the two, because the financial statements that are prepared by the board of directors also contain, in addition to numbers, as you know, some reports, a report on the management of the company. The board of directors has to explain how the management of the company has been performed during the year. And once these documents have been prepared and approved by the board of directors, they are submitted to the shareholders for their approval. The shareholders can decide to approve them or to reject them, and in the most serious cases, the shareholders can also file a claim for liability against the directors if the shareholders believe that the directors have performed some misconducts. Okay? This is again the ordinary shareholders meeting. One last input for you, 3-4 minutes. Today we have been talking about a share capital increase in KR Energy case. Your colleagues mentioned in the slides the role of the extraordinary shareholders meeting, right? Now, the extraordinary shareholders meeting was competent in the case at hand, where the matter at stake was a share capital increase, because a share capital increase implies an amendment of the bylaws of the company. The company has a chart, which can be more complex or less complex depending on the sophistication and complexity of the company itself, where all the rules of functioning of the corporation are listed. Article 2, Article 3 usually of this chart, of these bylaws, always provides for an amount in euros or in any other currency, depending on the jurisdiction, where the amount of the share capital is indicated. If you want to increase or to reduce the share capital of the company, you have to amend this number, and therefore you have to amend the bylaws. All amendments of the bylaws under corporate law fall within the competence of the extraordinary shareholders meeting, which is nothing else than the same shareholder meeting with the same person, but with a higher quorum, which is about 67%. Yeah, percent is a percentage. Okay. So you need, in our previous example, for example, Viviane would not have been able alone to approve a share capital increase because she has a 60% stake, and here instead you need a 67. So the other shareholders, the rest of the class that let's say together make the remaining 40% could have prevent this decision to be taken by voting against it. Okay? And this is, again, the reason why we have been talking about extraordinary shareholders meeting in the KR Energy case. In that case, we have a board of directors of KR Energy that found a business opportunity. A share capital increase where the asset that could be contributed were the SISPA stake. The board of directors detected this opportunity, went to the shareholders and said, dear shareholders, we can acquire 100% of SISPA through a share capital increase to be executed with a contribution in kind. This is the estimate made by the expert. This is the percentage of dilution that you will suffer. These are the incredible advantages that you will have as our shareholder if we buy SISPA. Do you approve the share capital increase, yes or no? The extraordinary shareholders meeting approved the transaction. Okay? This is what, in very few and unsophisticated words, happens in a corporate process of a joint stock company in Italy. Okay? Hope everything is clear. So, unless there are any questions, I would have finished, and we'll see you next week, where we will have, excuse me, on Friday, there will be the written exam, 2 questions on only this case, of course, because...
Not the introduction.
No, because we didn't discuss that, so we will only talk about it. Thank you very much.
Non ci capisco un cazzo, però scrivo tutto, poi ci rifletto. Esatto. Poi li mando a chat.
Lasci lavorare questa intelligenza artificiale.
Capito?